full and fulsome argument and hearing before, which will speak for itself. And I don't like to muddy waters when I make a ruling and then ultimately indicate I'm persuaded by one side or the other's arguments, because then I'll defer to the party preparing the order to sort of flesh it out with their arguments and their briefs, and obviously with the approval of the other side. What the outcome is going to be here today is going to be a grant in part and deny in part. And because I am granting in part, Mr. Fugazzi, I am going to ask you to prepare the order. The grant, so when we look at and I do like to sort of be old school about this, as we used that term before as well. We look at the 6 causes of action. I'm going to explain what is being granted, what is being denied, and then give you just a very brief summation of ultimately what's happening. But the overarching arguments related to jurisdiction and related to Section 230 of the Communications Decency Act sort of overarched, as argued, all of the causes of action. And I am not persuaded that either of those are applicable to warrant dismissal of any claims. So those arguments do fail. I do believe that there are sufficient minimum contacts with the state of Nevada to exercise specific jurisdiction over Snap Inc. I think it is clear that Snap Inc. does target Nevada citizens, Nevada minors, specifically related to this cause of action, and profits from their data. And ultimately, there is nothing unfair or unexpected regarding the defendant being subject to Nevada jurisdiction or held into jurisdiction in the state of Nevada. So I'm not persuaded by defendant's arguments regarding jurisdiction, but I am persuaded by plaintiff's arguments regarding sufficient contacts to satisfy and requirements to satisfy specific personal jurisdiction. I'm also finding that the allegations in the complaint can be construed as being based on conduct other than the publishing of just third-party content. And for that reason, I do not believe that Section 230 immunity or the First Amendment protections, as argued, would bar the complaint as written as to the totality of the claims. Where I am persuaded by defendants' arguments relates to the well, let me finish then. I also believe that the plaintiffs have articulated factual allegations and the applicable law that they could prove a set of facts potentially to entitle them to the Deceptive Trade Practice Act violations that they have alleged respectively as causes of actions 1 and 2. And again, recognizing that we are at a dismissal stage and that the standard here is any if proven set of facts could entitle plaintiff to relief, then dismissal would not be appropriate. And I do believe that there has been enough argument made that is persuasive that these claims are potentially viable, that any dispute as to whether they would be viable would really be factual based analysis, and therefore not appropriate for the dismissal at this time. The same goes for the negligence cause of action number 5. I believe that at this point in time, the allegations are there and that we would be dealing with factual analysis and having to stand as the fact finder in order to grant dismissal relief, which again is not appropriate under the standard that the court has to apply. Where I do believe defendants are persuasive and the plaintiff's claims fail are the claims 3 and 4 for product liability and claim 6 for unjust enrichment. I just do not see any set of facts that would permit these 3 causes of action to go forward, or even if proven would entitle relief. I believe that the case law and the surrounding factual information that's alleged show that this is not a product that this is a service, that in order to have a product subject to product liability and what is intended for that cause of action in the state of Nevada, and of course, we've looked at not just binding case law, but persuasive case law as well, that it just fails to state cause of action properly, and dismissal is appropriate where we are not dealing with a product with a design defect or a product with a failure to warn, such as is alleged here, when we are talking about this platform and the service that it provides. So I am persuaded that for that reason, plaintiff cannot show a set of facts which, if proven, would entitle them to relief as to causes of action 3 and 4 for product liability. And ultimately, the one that I think was not even a close call, the other one was a closer call, but as to the unjust enrichment, while the argument has been made that the state, whether parents, patria, or otherwise, somehow can assert that there has been their providing of a benefit to in turn then unjustly enrich Snap Inc. I believe I understand the arguments clearly, and I'm just ultimately not persuaded that there are facts alleged that would satisfy the elements of unjust enrichment. And therefore I cannot find that it stands. I am persuaded by all of defendants' arguments as to cause of action number 6. So the net result is the court grants the motion to dismiss as to causes of actions 3, 4, and 6. Product liability design defect, cause of action 3, product liability failure to warn, cause of action 4, and unjust enrichment, cause of action 6, for the substantive arguments made by the defense as to why the complaint and demand for jury trial, as it's styled, the operative pleading, fail to set forth facts which could be proven by plaintiff and ultimately entitle them to relief, but not, again, based on personal jurisdiction or 230 immunity. And then ultimately the court denies the remainder of the motion to dismiss and is persuaded by plaintiff's arguments that specific personal jurisdiction may be found, that 230 immunity does not apply to the Deceptive Trade Practice Act claims or the the negligence claim, and that ultimately the actual claims themselves substantively do allege facts which, if proven, could support relief for the plaintiff, and therefore causes of action 1, Deceptive Trade Practice Act violation, cause of action 2, also Deceptive Trade Practice Act violation stated for different reasons, and the ultimately cause of action 5, negligence, all survive as argued by the plaintiff. So that's the most in-depth I want to go into my articulation of my ruling. I will leave it to Mr. Fugazzi to prepare the order and obviously flesh it out with counsel. To the extent that there's competing orders or a dispute as to the order, you'll just let the department know so that we know that, and don't hastily sign an order that gets submitted. But if you can agree on the form and content and we can get this moving. I did not look, so I do not know how this comports with what was ruled by Judge Kishner with the other parties in her case. To the extent that there may be divergent rulings, in the end, that maybe only benefits should there be further relief sought at this stage, writ-wise or otherwise, or ultimately, depending on outcome of cases, on appeal. But I did not look, I do not know. I made this ruling solely based on my review of what was put in the briefs, what is of course in the operative pleading, and what was argued orally. Okay. Any additional record or clarification anybody would like to have? Mr. Jones.
Thank you, Honor. The only, we had a counter motion to leave to amend. And so I just wanted to ask, with respect to the claims that were dismissed, whether we can do that based upon your order today and understanding and listening to your order today. We would at least like to have the opportunity to do that, whether you think that we can fix the problems that you've identified. I guess, but I did want to make sure to bring that up and ask you about that.
So I think, I hate to muddy the waters too much, but I don't see how, with the way the court has determined the service provided by Snap Inc. to not be a product, that there is a way to allege around that. So I don't see how I could give you that relief there. And thank you for reminding me though that there was that counter motion to amend. It actually came up in a matter earlier this morning where we had a little back and forth with the council about when a sort of leave to amend without an actual pleading to support it, is appropriate in circumstances where obviously it's really as an alternative to trying to have a motion to dismiss denied, but if it is not denied, then that as an alternative relief. The closer call to me would be to the unjust enrichment. But again, based on my being persuaded by the arguments of the defense, I don't see where there is any ability to make factual allegations there either, because the court's determinations that as a matter of law, this is not a product and the state just simply cannot allege that it conferred the benefit, even again, as its role potentially as representing the individual citizens of the state of Nevada, where it can do, say it conferred the benefit. But I guess to make the final call on that and to be clear, I'm going to, out of an abundance of caution, say that should the facts come to light that would, you believe, permit amendment, then you can make a motion to amend to get the court to review that before amending. I don't want to say it where it's precluded entirely, because I don't think that is appropriate exercise of my discretion, but I don't want to indicate either that you should just tomorrow try to change up these allegations and think that that's going to fly, because it won't. There would need to be further factual development, I suppose, or you know, some other change in the law, if you would, from our appellate court here, or something that would beget the court's belief that you now have a basis to allege facts that potentially could entitle you to relief on the product's liability or the unjust enrichment before you can amend.
And you anticipated my next comment, which was, and that what you just said makes sense in light of your current thinking about things. So our request would be simply that they be granted without prejudice, so that if the discovery develops facts that we think are sufficient to address the issues that some of the concerns you've expressed today, we'd be allowed to bring an actual motion, so they would get the defense would get the opportunity to respond.
I think that's I didn't mean to interrupt you, but I think that's a fair ask. And we'll give that clarification, subject to Mr. Fugazzi if he has any further clarification or wants to dispute that.
I won't dispute it now. I think I'll wait if and when there's a motion.
If and when.
Your Honor, if in making your ruling, did you reach a conclusion as to the AG's standing to bring common law claims?
The best way to answer that, I guess, is yes and no. The way I made my rulings today ultimately were maybe not getting into the weeds of all of the variations of the various arguments that were made. But what I can say is that I do believe that the AG has the ability to bring common law claims based on the arguments made by the plaintiff, and that was not a basis upon which I made any of my rulings here today. So to the extent that you're seeking that there be a finding, I guess the way I would state that finding is I was not persuaded by defense arguments that the AG's office was without the ability to bring common law claims, but that was not the deciding factor. I hope that answers your question.
It does. Thank you, Your Honor.
Anything else?
No, Your Honor.
All right. Thank you all. Now you can